Harassment based on a person's sex, whether it's an applicant or an employee, is against the law. Two types of sexual harassment must be prevented: quid pro quo and hostile work environment. Quid pro quo is a legal term meaning this for that in Latin. Quid pro quo harassment occurs when a supervisor or manager requests sexual favors in exchange for a favorable employment action. The term sexual favor comprises a range of actions from unwanted touching to more explicit requests. Harassment is illegal when it is so frequent or severe that it creates a hostile or offensive work environment or results in an adverse employment decision, such as the victim being fired or demoted. If the actions or behavior are highly offensive or intimidating, the EEOC may determine that harassment has occurred. Harassment can also include offensive comments about a person's gender. For instance, it's illegal to harass a woman by making offensive remarks about women in general. The EEOC considers various factors when investigating charges. Often, a single instance of inappropriate and unwelcome behavior does not constitute a hostile work environment. The law doesn't prohibit simple teasing, offhanded comments, or isolated incidents that are not very serious. The harasser's conduct must be unwelcome. Thus, it is important that the victim inform the harasser directly that the conduct is undesirable and must stop. Sexual harassment may also occur without economic injury to or discharge of the victim, and the victim does not have to be the person harassed, but could be anyone affected by unwelcome offensive conduct towards someone other than themselves. The harasser can be the victim's supervisor or supervisor in another area, a coworker, or someone who is not an employee, such as a client or a customer. Both the victim and the harasser can be either a woman or a man, and the victim and harasser can be the same sex. It is illegal to retaliate against an individual for opposing employment practices that discriminate based on sex, or for filing a discrimination charge, testifying or participating in any way in an investigation, proceeding, or litigation under Title VII. It is advisable that employers establish a transparent complaint or grievance process and take immediate and appropriate action when an employee complains.